at 7:30. Call this meeting of the Plan and Zone Committee to order. First on our agenda, well, actually, I'll say everybody's in attendance. First item on our agenda, John Putzer, 2679 Moss Lane, Town of Brushwood, special exception.
Staff report is as follows. John and Kate Putzer are the applicant. Tax parcel number is 022-0837. Special exception number 23-SE-001. Explanation. The owner applicant is requesting a special exception to construct a garage on a vacant lot adjoining a lot with a principal structure. Town recommendation. The town of Brushwood has not responded. Preliminary findings. 1. Proposed special exception meets ordinance requirements, allowing an accessory use on a vacant lot adjoining a lot with a principal structure under the same ownership. Number 2. Proposed special exception meets the intent of section 23.8-45, establishment of an accessory land use prior to establishment of a principal use, and section 23.7-214, basis of decision, in totality. Recommendation is for approval with the following conditions. Conditions, number 1, tax parcel 022-0837 shall be deed restricted to tax parcel 022-0838 for the lifetime of the proposed garage. Number 2, deed restrictions shall be recorded with the Register of Deeds prior to the issuance of any permits.
Thank you. Tom?
Town of Rushford is in favor of this, and the reason they didn't buy, I guess, is because all this said about this meeting coming up, it didn't say any place like other ones where, yes, you will go along with it or whatever, but the town of Rushford did approve this, as far as the approval of it, they know where it is and everything, so I will make a motion to go ahead for the special exception for the John Putzer at 2679 Lost Lane.
I'll second it.
Okay, it's been moved and seconded. Any other discussion on this item? Just want to say it's nice to get back to deed restrictions being in the proper place. Sorry, I couldn't resist. After the whole
I just have a quick question for Brian. So for the lifetime of the proposed garage, I don't know that we, in prior ones, is that what we also said? Okay, as long as, because that caught my eye, I know what I just wanted. Clarification. Okay, thank you.
Anything else? See no more discussion. All those in favor, signify by saying aye.
Aye.
Any opposed? Passes. On to item number 2, Scholar Ridge Estates, parcels south of intersection at County Road, I and Martin Drive, Town of Clayton, preliminary plat.
Staff report is as follows. This is for a proposed preliminary plat in the town of Clayton. Comments. Number 1, development is proposed to be serviced by public sewer. 2, development is compatible with adjacent development. 3, road construction agreement with the town should be executed prior to submittal of final plat. Recommendation is for approval subject to the following conditions. Number 1, A, DNR review of surface water runoff and or detention facilities is required prior to final plat submittal if any portion of the subdivision is within 500 feet of a navigable body of water. B, any necessary chapter 30 permits required in connection with the provision of surface water runoff or detention facilities shall be obtained prior to final plat submittal. Number 2, final plat shall constitute the entire area of the preliminary plat. Number 3, final plat to contain a restriction that roads shown to the exterior property lines may not be vacated without the express written approval of the Winnebago County Planning and Zoning Committee, it being the intent of the restriction to prevent elimination of right-of-way required as a condition of preliminary plat approval by Winnebago County without their authorization, Number 4, street names, if any, be verified in writing by county GIS office prior to final plat submittal if not approved prior to preliminary approval. Number 5, final plat to clearly show all current owners' name, corporation title where applicable, and or corporate name. Names to be clearly shown underneath the signature lines. Number 6, final plat to be reviewed and approved by GIS office and property lister prior to scheduling for final approval. Number 7, final plat to have the following statement contained on the document, this plat is contained wholly within the property described in the following recorded instruments, list appropriate document numbers and corresponding tax parcel numbers, Number 8, prior to scheduling final plat for approval, written confirmation by the appropriate sanitary district that the development is being serviced by public sanitary sewer shall be provided. Number 9, any official mapped rights of way shall either be shown as mapped on the final plat or written notice from the mapping authority shall be submitted to the county stating that the mapped rights of way need not be shown because the map is being amended. Number 10, a note shall be placed on the face of the final plat stating, Winnebago County shall not issue any permit for construction until such time as a sewer permit or other suitable written construction authorization has been issued by the sanitary district for connection to the district's facilities. Number 11, a wetland delineation shall be submitted to the DNR and Corps of Engineer for their approval. A written copy of the aforementioned agency's approval shall be filed with this office prior to scheduling of the final plat. A copy of the delineation and accompanying maps shall simultaneously be filed with this office. The preliminary plat will not be approved. Said delineation requires a major lot reconfiguration. In this instance, this preliminary plat will be denied and a new preliminary plat and review fee will be required. Number 12, a note shall be placed on the final plat stating, any riparian lot and or lot wholly within 300 feet from a navigable body of water shall be subject to county impervious surface standards, Number 13, the final plat shall not be scheduled for approval by Winnebago County until such time as a written confirmation from the town of Clayton and Village of Fox Crossing stating their approval of said plat be submitted to this department. Number 14, a zoning change from town zoning non-shoreland jurisdiction to county zoning shoreland jurisdiction R2 suburban residential shall be required prior to final plat submittal. This zoning district will be required for all parcels or portions thereof under county zoning jurisdiction. Number 15, the active county variance request for the placement of roads and walkways within the shore yard shall be approved prior to submittal of final plat.
Thank you. Yeah.
I'll move for approval to get it on the table, and I have some questions.
No, second.
Okay, it's been moved and seconded, Tom.
Um. Final plat is solely, current owner's name and corporations. So everyone that owns this piece of land's name will have to be on the plat,
Yes,
and you'll see
the
that.
property lister checks that.
Okay. And number 15, nothing really to do with this, but I know this comes up quite a bit. I know Supervisor Miller brings it up quite often. Here it says like the town of Clayton and the village of Fox Crossing has to approve this in order for this to go through. Well, I know different times we brought up other objects. We'll just say, I think the last one was in town of Nina. They did not approve that, but still we went ahead and we approved it. So what makes it because it's a plat is because they have the right to go ahead and we hear them. If they don't approve it, we don't approve it.
They have their own subdivision ordinances and
Okay,
they review this based on that. If they would deny this for any reason, we would put this back on another deliberator for you to discuss their denial.
okay. All right,
I don't know about the Village of Fox Crossing, but the town of Clayton has approved it. So I talked to their town planner on Wednesday.
I guess that wasn't it. I'm not saying that they probably
Yeah.
wouldn't. I'm just saying that we
Yeah,
have had
yeah,
other
yeah.
things come up besides, and that caught
Yep.
my eyes.
Questions?
Sure.
Just a couple questions for Mr. O'Rourke. So what determines what the navigable waterway? Is that the DNR?
DNR.
Okay, so, and then how does that? With GIS data? Is they're in control of the GIS data?
No, they make the determination whether it's navigable or not. They submit that determination to us and our GIS departments. Changes that either navigable or non-navigable based on that determination with a reference to the date of the determination.
So the GIS is all connected to the DNR and they're doing what the DNR is saying?
They do what the DNR submits to us.
Okay, oh, yeah,
They're just reacting to them. They're not making a decision on anything.
okay. So, is there ever a time when they're looking at the map, just overall map and determining that it's what's navigable and what's not, or are they on
Who's
the
they?
field?
Who's they?
People,
GIS does not make that determination. DNR does.
okay, so DNR, do they go onto the land and look, or are they looking at just the maps?
No, they do a field check.
Uh-huh,
And the field check for this one, which determined the stream navigable, was based on a permit application by the applicant for the subdivision.
okay, so they are doing field checks.
Yes,
They're not just looking at
no.
paper.
Mm-mm.
Okay, thank you.
Okay, as long as you ask that question, I brought a couple of photographs. These photographs were taken at Clayton Road, which is the nearest road to Clayton Road is right over here. Property that we're looking at is here. Clayton Road is right here. I took some photographs of that navigatable waterway. The bottom photograph was taken on the east side of the road, and the top photograph was taken on the west side of the road. Now, right now, there is no water in that ditch. On the west side of the road, if there was water in that ditch, there is so much brush in there that there's no way you could float anything, anytime.
Okay, so I have a comment and a question. We have a navigable
Did you want to see this?
waterway out by me. And I was told back in the day when this went down. All you need for stipulation is you're able to float. Boat,
Bed and bank and to be able to float a watercraft 1 day per year.
correct. That was that was gonna be my statement. Then and not really a question, but we're here to either approve or not approve the preliminary plat. Everything you read was before the final plat could be
Right.
approved. So if we approve this, then you're in charge of all of the stipulations you read off. or-
Before we would schedule the final plat for approval by you, we would verify that all conditions, if included in an approval are met.
That's all I wanted is that clarification. Okay.
Did you want to see that, Mr. O'Rourke?
No, I've been on the site.
Okay,
I know what
sorry.
it looks like.
Okay. I just threw it at you there.
That's the thing, and that's the thing that catches a lot of people up with the navigable waters, the 1 day a year.
But is
Yeah,
it
but
floating
There's so
from
much brush in there, you couldn't float anything anyway.
that
there
1
was
day?
water.
Committee does. decide
Keep
navigable.
in mind, we would be reviewing this plat regardless of whether or not there's
Yeah.
an navigable stream going
Right.
through. That just changes the
Yeah.
requirements for those parcels within the 300 feet of the navigable body of water.
So when they say navigable and you can float, are you 1 day a year, you're able to float from A to B through
It just
that?
says float. That's just their general
Okay.
guideline.
That just,
It's mind boggling.
it comes
It's
across as
mind-boggling what they
being,
consider navigable.
We had a conference call with the applicant and the developer, and we indicated to them that they should ask for a second opinion on the navigability determination. They didn't do it, so.
But they've also changed the plat layout since the first plat layout.
Slightly,
Slightly, because of that determination. by the
that's
DNR.
our analysis, yes.
Yes, okay.
Yeah.
Okay. Thank you.
And it didn't sound like they were upset with it. So,
That's
I
all.
mean,
I
we
have.
can disagree about the navigable water.
Yeah,
All we
and
want,
that's,
but the
yes,
petitioners,
that, I mean, that doesn't,
Yeah.
I'll support this, but.
But, but it,
Yeah.
This is just informational.
right,
Yeah, but the thing is that if the DNR is coming and I don't feel like that. I understand what, there was a comment that we don't determine. What is navigable or not,
That's the state.
but if I don't agree with the state. Then should I be voting on it?
Keep in mind, you're talking about a determination on a navigable body of water, whether it is or not, based on anybody's opinion, we're reviewing the plat overall.
Yeah.
Not that one thing.
So
Yeah.
either way, either way, you'd be in the same spot you are now, whether it was navigable or not.
Yeah, but doesn't that set a precedent for the next time and the next time?
I mean, what the DNR
just-
does is on them. We don't regulate the DNR. They're their own entity that has the authority to deem things navigable and non-navigable. And if the owners were upset about it, they could have reached out to the DNR.
Yeah,
And we advise them of such.
I can't, I can only assume the owners decided that it would cost them less money to change their plat than to try to fight the DNR.
you would think.
Yeah,
so if everybody's setting the precedent is the land, if you were saying there was a precedent, it would be the landowner because they're the ones who are saying, okay, we're fine with that.
And
We're
they
we're
would-
going with what they said, because it would be them who would take on that fight, not us.
mhm.
And they went ahead and changed their preliminary plat that we first saw to what we have now today. So I'm figuring they're just gonna roll with this
I'm
because
sure
they
they
wanna
are.
get moving.
I'm sure they are.
And I don't see where it sets a precedent, but I'm not an attorney.
Yeah, like I said, it's on the owners to fight that fight,
Yeah.
not us.
Yeah.
Okay.
I mean, think about it, if it was on the municipality or the governing body to fight it, how hard do you think Oshkosh would be fighting over Pioneer Island? That's been sitting dormant for decades.
okay. All right,
Any other discussion on this? Seeing none, all those in favor signify by saying aye. Any opposed? Motion passes. With that, our agenda is complete.
You do an adjournment.
move to adjourn.
Second,
That's what I was just asking for, Brian.
So,
I can read your
All
mind.
those in favor?
I,
Aye.
None opposed, meeting is adjourned.
oh, yeah. Oh,
Okay, call this meeting, planning and zoning committee to order. And before we start, I just want to ask if anybody has their cell phones on, make sure you silence them, please. Because,
It would be disruptive.
yes.
Yeah.
Item number 1, approval of minutes from May 30 public hearing, June 9th deliberative and planning, June 23rd viewing, June 27th public hearing, July 21st viewing, July 25th public hearing, August 4th deliberative, and August 25th viewing. Boy, we're slacking.
So the document I handed out to you, the time was wrong on the June 9th deliberative.
Mhm.
So they were amended with the proper time. So any motion to approve those minutes would have to include the amended June 9th deliberative minutes.
I move to approve with the correction.
second,
Okay, it's been moved and seconded. Any changes, corrections, deletions? I do have one on the one that we have in front of us. I'm pretty sure Paul Lipple does not have an H in his name, just so that's a typo, so we can take care of that one. Just wanted to bring it to your attention. I only know because I went to school with him. Any other? Yeah. All those in favor?
Aye.
Any opposed? Okay, minutes are approved. Move to our public comments.
Well, I would like to make a comment. Can I sit in the?
You can Eisen it all you want.
Oh,
Eisen?
wow.
Eisen? So I'll go ahead.
Name and
I'm-
address.
Shauna Zestera, 1882 Clareville Road, Oshkosh, 54904. So thank you for allowing us to speak. Planning and zoning is a good committee for me to sit on. I find that it's the Constitution is really at play when I sit on a committee like this, and one of the reasons why I like this read is because of the blood that has been shed for our country. And it is a basis for my faith. And our country has been founded through blood, sweat, and tears. And we need to be very diligent about upholding our Constitution and the sacrifice that has been made for it. And I would direct people to possibly listen to a very informative broadcast every day at 1 o'clock, 2 o'clock, and part of it airs again at 8 o'clock, right out of Milwaukee, called VCY America, 690 AM, 89.9 FM. These programs are there for us as citizens to be aware of what is going on every day throughout our country. We have to be aware that there are people in our country and outside of our country that are wanting to undermine our rights and our freedoms. They don't like America. And I'm not making accusations amongst our county government, but we do have to be on guard. So one of the benefits of being elected is that I represent constituents, and I also just simply share my mind on things as well. And one of the things that I have seen with planning and zoning issues that confuses me is why we are not able to look at billboarding along the interstate, one of the highest sex trafficking veins or arteries, as nuisances when it comes to legalizing cannabis, as well as, or going to Michigan for cannabis, as well as adult shops and so on. This is to me, a stain in our county that our planning and zoning department should look at. I know that Mr. Rowe has addressed with me the adult shops.
If I could interrupt for just a second, we're supposed to, it's agenda items.
Agenda
that we're supposed to be
items.
Talking about.
Okay, so the Constitution. So I can't share on anything besides agenda items?
No.
Okay. All right, well then I will talk about Sawyer Creek. And I will keep this brief. Sawyer Creek, I just saw an ad yesterday. And I don't know if the city has been part of this or not, but there is a development opportunity, 5 acres, $345,000 for sale along Sawyer Creek, and it's advertised along Sawyer Creek. And I don't know if I can crosstalk with Mr. Okay, so I just saw it, it's an ad. 5 acres along Sawyer Creek, $345,000. When I speak about the Constitution, property rights are very important. They are one of the primary rights. If you look at the allodial land contracts, those are land that has to do with allodial status. This is a very important thing for people to have their own rights. So I will leave it at that. Thank you for your time.
Thank you. Anybody else?
Bill Benson, 2091 Clareville Road. When I saw earlier this week that the committee was gonna meet on this, I thought I probably felt as though I should come and say something and really didn't know what to say because there's a lot of things probably that could be addressed when considering if we should move this to public hearing again or not. And I think that there's so many details and things have been problematic and riddled with issues since the beginning. And the county's never, I don't think, been on board with this. County never signed up for it. First planning and zoning meeting, committee denied it. You know, it's gone to public hearing a few different times. The board denied it. Interestingly, it came back 5 months later and made its way back to the board. The board again pushed it back to the committee. This committee's all but denied it. And I don't, it has all the same issues. It's the same mapping and what new information is there? And when things don't seem right, generally they're not. And there's usually rules and things, laws and things that address that. And you know, it doesn't seem right. You can drive 70 miles an hour down Main Street and but it's not. And there's rules that address that. And I think in the big picture, I think we just get mired down in all the details and we kind of miss the big picture. And I think it's important to look at it a little more in the big picture. And you know, the city, and we always say the city, and I don't think this is the city. You know, I think this is a product from the employees and planning department and engineering department in the city. This didn't come from the common council. This didn't come from the plan commission. And those employees with some input from employees in the planning and zoning department have created this issue with federal maps that affect the county. It doesn't seem right that I don't know how many people are in those departments, 20 total. It doesn't seem right that 20 people can make decisions and affect something on this scale that affects a county of 170,000 people. And if it doesn't seem right, it's probably not. And there's laws that address that. And I think more importantly, in the big picture, what this committee does, planning and zoning committee is the ruling body and the authority in the county. And it's a lot of responsibility. The committee is responsible for the comprehensive plan. That's an important document. It steers in the direction of the community, the county, and affects people. It has a lot of impact. And when the committee makes decisions on helping people with their zoning, no matter how small, those decisions have a lot of impact for those people, financially and otherwise. You can build a garage. If you look at the comprehensive plan, how does it address flooding, flood mapping, and flood storage? It doesn't. And to change zoning on land that doesn't fit the comprehensive plan, doesn't seem right. It's not. And more importantly, I think the bigger issue is that rather than be reactive, we need to be proactive. Not only with maps, but with flooding mitigation in the county. The entire county. The citizens within the city of Oshkosh are residents of the county. We owe it to the county to be proactive and do something about the flooding that we have. We're flat. And if the committee decides to put this amendment to bed, I think it's important in the big picture to do something, to take the next step. I think it's in some ways, it's a responsibility of the committee to steer what we're doing for flood mitigation and mapping in the county. To do something that's clear and above board and transparent and collaborative. We could have some sort of advisory group and it could have representation on it from all the stakeholders. It should have representation from the city of Oshkosh and the city of Neenah and the city of Amro and the towns and the villages. All entities that have elected officials that represent constituents that can bring information and ideas on board. There's the Winnebago County Land and Water or Water Conservation Department. There's the Fox Wolf Watershed Alliance. There's watershed districts. There's people with their boots on the ground that are dealing with the water that we have in our county. Imagine the amount of horsepower that we would have at the table to make decisions and to do things that are effective in mitigating water, to draw puddles, large puddles on a map that may store water for a matter of hours once every 100 years. Doesn't seem like that solves any of the issues that we have as a county with flooding. And how this has been handled from the beginning, I think is embarrassing. It's just a bunch of posturing and them versus them, and it's this game of who can be more. It's not a game. I think it has real impacts and real effects for a lot of people. And I think the committee should do something to be proactive. And I'm not wouldn't plead with the committee to not put zoning on my land. You decide what you think is right. If it's, because if something doesn't seem right, it's probably not. There's probably rules that address it. If I were to plead with you to anything, I would ask that you do something that's in the best interest of the entire county. The maps that we have are from flood insurance study in 2003. It used some of the data that it used is from the 70s. It's 50 years old. Arguably, the maps need to be updated. Not just the Sawyer Creek watershed. If you look at the map, I'm sure we've all looked at the map, and you look at Sawyer Creek and you look at the 100-year floodplain that goes through the city of Oshkosh, it's a pencil thin line relative to the county. That map is supposed to show the amount of flooding you're going to have in a 100-year event. When you take the storm from 08, approximately a 75-year event. And there was what, 29 million in damage and 4,000 affected structures or something like that. Way more. The flooding has way more effect than that map shows. I would argue that we have an obligation to do something. You're the governing body of the county board, planning and zoning. If you don't do something beyond this, the next Jerry Springer show is right around the corner. We can be reactive to that and spend as much time and effort and money as being proactive. And it doesn't to do mapping and to mitigate flooding. If you don't do it transparently and collaboratively, if you do it any other way, it doesn't seem right, and it's not. Process is clearly, there's rules that address that, and the process is clearly set up. And I really believe we don't need to drag up any more mud. There's enough. We need to put our effort into doing something positive and proactive. So thank you. And excuse me, sir, and because I don't mean thank you, I'm done. I just mean thank you for listening. Thank you for listening to me. Thank you, the committee of all the people, of all the keepers of the information that just hide it and shroud it and withhold it and manipulate it. The committee is the only people that have listened. And if it went for the committee, no one would have known about this. And thank you to Brian Defferding, Supervisor Defferding, who served on the last committee that's not here. So, thank you.
Thank you. Didn't want to have to cut you off.
No, that's fine.
Had you kept like you were getting there, so I didn't want to.
Yeah, oh yeah, absolutely, yeah.
Anybody else?
I need just a minute, but yeah. I don't know if somebody needs to speak.
You go to the city of Oshkosh here to answer questions and listen if he has any questions.
I have a question. If
We'll
he asking,
we'll get to that after public comments.
Good morning. Jessica Bradley, 2633 Neck Road, Oshkosh, 54904. I wrote stuff down because, as many of you know, I tend to get a little passionate. And I really just want to try and stick with a few things that I want to specifically address that affect the committee. So here we are again yet to talk about this application for the zoning map amendment. You have three options placed on the agenda today. Rescinding the committee April 14th vote, which was approved, not sending the Sawyer Creek floodplain amendment application to public hearing. 2, sending the Sawyer Creek floodplain amendment application to public hearing. 3, withdrawing the Sawyer Creek floodplain amendment application. We have talked many times with this committee and the committee before about the effects of this application. I think we all here agree that there are many different views on how the zoning changes will affect the landowners. Today, I want to talk about the application and point out a few important facts. Have all of you on the committee seen the application? Are all of you familiar with the entire application? Including the instruction sheet that comes with it? It's posted on the county website. So when we look at this application, highlighted, all property owners must sign application. Use additional pages if necessary. There's additional pages on here. This one, it says varies, see attached. NA. Interesting. As I look at this, I do not see a signature for the parcel of land that has been in the Bradley family for over 100 years. That my husband's family, his parents, his grandparents, and his great-grandparents busted their back to pay taxes on, to purchase, to raise their families. And they don't have the right to sign the paper for a zoning change that will affect my children, my grandchildren, and my great-grandchildren. On the instruction page, it says, property owner must complete and provide original signature. Redundant, I know, yet it's not done. I hereby appoint the following as my agent for purposes on the application. Zoning Department, Winnebago County. Signed by Carrie Rowe. I would like to see the document that shows myself or any of the 20+ landowners authorizing and or appointing Winnebago County Zoning Department or any of its employees to act as my agent. So I move on then from minutes from the meeting on June 8th, 2018. From the Planning and Zoning Committee. Strand and Associates have requested a signature from staff members of the Planning and Zoning Department in order to submit a letter of map revision to FEMA. With a subsequent zoning change at the city and county level in order to revise the area shown as flood storage. However, in having conversations with the city of Oshkosh Community Development staff, it was indicated to him that none of the property owners who would be affected have nor had been notified of this proposed change. Therefore, he indicated that he would not be notifying, that he would be notifying the engineer requesting the signature of county staff, that the document would not receive signature from the would not receive a signature from the county until such time as it can be verified that some type of public outreach has been conducted, as well as notifying each individual property owner that would be affected. There was a consensus of the committee that a zoning change to amend the county's floodplain / flood storage map at the county level would not be initiated until such time as the City of Oshkosh Public Works Department and or Strand and Associates can verify the actions previously described have been conducted. Zoning map amendment application submitted by Winnebago County Zoning Department, January 15th, 2019. The date right on. Landowners finally notified by Brian Defferty And a letter then that we received that was dated on October 8th of 2019. 16 months after the Planning and Zoning Committee stated nothing would be initiated until the landowners, the ones that'll be affected by the zoning change, were notified. Let's think about the date that that application was submitted by the zoning department. 7 months after the Planning and Zoning Committee stated nothing would be initiated. 9 months before the landowners were notified. Who drives who? Now, I'm not an expert on this by any means, but my simpleton understanding is that the county board, i.e. this Planning and Zoning Committee that has been a great sounding board in listening to us, is the one that should be directing the Planning and Zoning Department. By this being signed, when it was stated that it would not be initiated, the Planning and Zoning Department, I believe, at somebody else's direction, sent this application. So here we are, 2019, 2020, 2021, 2022, 2023. We are 4 years into this. Today, for me to come to this meeting, I had to pay someone to cover my work. This is not the first meeting that I've had to do this. This, I guarantee, will not be the last meeting. The people that are here fighting against us as property owners are being compensated to be here and to fight against me. This project was brought on by the city without the involvement of the county or the landowners. The city hoped we would just roll over and let this slide through without any resistance. And we all know that. We all know it. It's wrong. There are reasons why laws are put in place. There are reasons why there are people that are put in place to govern over employees. It has been 4 years being on the defensive to protect the value of the land that has been in our family for over 100 years. This is wrong. I should not have to defend my family's future on our farm. But as God willing, you all know, we will continue to fight, and we will continue to discuss this, and we will continue to be here. And people need to be held accountable for their actions and how it affects other people. And this application is not legitimate. And what is trying to be pushed through is not legitimate. Thank you.
Good. Do you have anything you wanted to say, Steve, or?
I'm here to answer questions.
Okay, just making sure.
Thank you.
Okay. Back to the committee. Okay. Next item will be discussion and potential action on one or more of the following items. A, rescinding the committee's April 14, 2023 vote, which approved not sending the Sawyer Creek floodplain amendment application to public hearing. B, sending the Sawyer Creek floodplain amendment application to public hearing. C, withdrawing the Sawyer Creek floodplain amendment application. Okay. Can we discuss this without having a motion on one of those items?
Discuss the whole concept of
Yes.
Sawyer Creek? Yes,
Okay,
You
just
can.
want to make sure
yes.
we're
But
not
you're,
out of turn because generally it's motion, second discussion, so.
the key is making sure in terms of transparency that we list what we're gonna be talking about.
Right.
If these are the three issues that are gonna be raised, then I think you're covered for,
Okay,
the
just,
concerns
I
regarding
just want to
approval.
make sure I's and T's.
yeah, no, that's fine.
So with that said, we know. I just want to start out with this. We know for a fact, because the city has stated it. That if we take no action on this. They can petition the DNR and go around us.
Come again, I'm sorry, could you repeat?
At the last time we did this, we learned that if we take no action or if we. Rescind this. The city can basically do an end around. They can petition to the DNR directly. Am I correct on that, Steve?
I don't think I have the expertise.
Because I thought that's what we got at the last meeting. Am I correct on that, Mary?
Yes, you are.
Okay, so us taking no action is basically giving the city free rein,
Assuming they opt to do it.
if assuming they opt to do it.
The city department, the specific department. Which is what department?
Well, it would be the city as a
Yeah.
whole acting on their behalf.
Right, right.
And
That would have to go, my belief is that would have to go to the council or city manager. That would not be something.
City, I think it's city manager.
so it'd have to go to common council first.
He's not a lawyer,
Yeah.
Say thank you.
This,
so I don't want, but I,
and I will remind you, because I was on that plan commission, this was passed by the city. Years ago,
this,
this mapping.
okay,
This mapping was passed by the city at least 5 years ago. So around the same time it came through here.
Common council looked at,
Then it went to the council after that, and I believe they passed it as well. I don't remember anything that we passed that they didn't. So, so the mapping has already been approved by the city of Oshkosh. That I can go to Steve about.
That I can confirm.
Yeah.
Within the city limits.
So, so as far as within the city limits, that's been approved.
Mhm.
That kind of, I think that kind of tells you where the city's mindset is, that they want, you know. So
at that.
I'm not gonna put words in their mouth. I'm not gonna say they're going to. I'm just saying. That there's a series of events that can lead you to thinking that they may take their own action. I don't know, and that's one thing we have to run through our own minds. Are we comfortable with that, the potential of that happening if we take this away
But they
right
would,
here?
but if they did that. It would have to, correct me if I'm wrong. What is your department? What is this department again?
So your
Public.
public works.
Okay,
yeah.
so your Department of Public Works. Would have to. Reach out to DNR. And all of that, and that would still have to go through common council, the mayor, etc. For approval.
Can't say for sure on that, because I believe it's already been approved. It's one of those. that-
I don't know the answer to that. I think they have corporation
assume-
counsel.
Yeah, I would assume it would have to, yes,
Okay,
but as Mary Ann said,
Mhm.
it would have to go through the whole
it
vetting. Or,
probably does, yes.
I would assume so.
Okay.
I'm just assuming that, but
Mhm.
I. Take that for what it
And
is.
not, as you-
He's not a lawyer. He's not a lawyer. no.
but you know the process though, right? You would know the process, so I would think that you could answer that.
It wouldn't only
have
be,
the expertise to know the details of what would be required.
Okay,
and I don't think it would just be public works either. You'd have planning involved and.
okay, all right. I'm done.
You're done?
I'm just laying that out there because that's kind of hanging over everything. I know last discussion I had, there was nothing, they weren't planning on anything, but we've kind of left everything in limbo by not taking an action and just leaving it stuck here.
Who is they were not planning on anything, if I can ask.
the city.
Oh, yeah.
Last I heard, when I talked with people, it was Mark Lyons, he said that he had not heard anything as far as that end around strategy, so.
I'd like to ask Jerry in the department a question.
Sure,
If this was let go, if took the application away,
right,
they would have to make a new application too, correct?
yes,
So let's
Exactly.
start the whole thing over.
right, that's correct, Tom, yes.
At this time, I'd like to recommend item number C, withdrawing the Sawyer Creek floodplain amendment application.
Second.
Can't make sure that was a motion, not a recommendation, so.
Nope, that was a motion.
I second.
Yeah, just for the record, I was,
That was a motion.
yes,
It doesn't matter to me.
I'll second that motion.
okay,
Okay, now can we have discussion?
it's been moved and seconded.
Okay, my discussion is, I've been here through this whole thing. And the first time that Carrie Roll put the map on the table, I said, have all the property owners been notified? And he said, no. Okay, that's where I'm coming from. That has not changed. And that's what brought around notifying them. And the notification went down in many manners, and everybody knows. Those of us on the committee delivered letters. Brian Defferdine being one of them. Mailings went out from planning and zoning. But people didn't get the notifications, all people. So that's why we drove around and delivered letters. Whether that was good or bad, doesn't matter. That's what we had to do. So I've sat here for 5 years, almost 5 years. And seen some shenanigans going on, because I don't know what else to call it. Some manner of continuity between the city and between the county. I represent people in the city and in town. I thought the mapping was atrocious. That it just came all pre-finished and expecting us to accept it. I have spoken before about public hearings. We've had enough of those. So being that C is the only option, and it's not that we didn't intentionally take action on one of these three the last time. I just felt it was crammed down our throat and I wanted time to think about it. So as of today, the only option for me is withdrawing the Sawyer Creek floodplain amendment application and starting over. And perhaps we'll get updated maps. Perhaps we won't, I don't know. There's been a lot of money spent by the city. A lot of time by us. I just think this whole thing is not right. So to withdraw and start over. It seemed the only option I could take today. It would be a fresh start.
Okay, before anybody else speaks, I just wanted to clarify with staff. Because it doesn't specifically say on here, start over. Is that the process that will happen? That it will start over?
No, I mean, that's completely optional. I mean, at this point, whether the city comes forward with an application itself, which it can do. Or the committee, at a future meeting would direct staff to prepare a new amendment application for this purpose. That would be your call, but at a future meeting.
But not something we can,
But,
not something we can do today on this, because it's not.
No, I
specifically-
mean,
Yeah, I'm just
yeah, I
making
think,
sure we're all
you
clear
know, I
here.
think it's, you know, you need to take a step back after whatever action you take here today and.
Right.
And let that sink in and then see where it goes. I don't know, but either the city would come in with an application potentially. Or nothing, or something that nothing may happen.
And I don't want to speak for everybody, but I'm gonna speak for the heads that I did see nodding. I think if this particular motion succeeds with it, when we do vote on this, it seems like the will of the committee. So it's something just to keep in mind, you know, that it could be coming back, that we would want the process redone in a different manner where a lot of these issues
Yeah.
were. So just letting you know.
Yeah, that'd be your call, sure.
And I'm sure the committee knows this because we had talked the last time about the issues with FEMA and FEMA's directives and the DNR's directives. But I was just provided, again, yet another, some correspondence from the DNR. And again, asking where do things stand with Sawyer Creek? So it says DNR has agreed to work with the county, but this still needs to be acted on and not just tabled indefinitely. Again, just so
Mhm.
you folks have all this information, and that was an email dated August 21st, 2023.
So is that tabling indefinitely?
No, what we're doing isn't tabling it indefinitely. What we're doing is rescinding.
Okay.
Yeah.
All right.
That's
just
a
wanted to
different, what we
clarify.
did was tabling it indefinitely.
All right, okay, thank you.
That's why we said we needed to take an action today, because leaving it in limbo.
It was in
land.
limbo.
Yeah.
Nothing was done at the last.
Okay, thank you.
So,
I'd like to see a lot better.
Go ahead, you know.
I was on this right along with Mary Beth, and Brian Depperding was very active in this, matter of fact. When he went to Washington, he even went and talked to some of the people down there. I think you've heard me talk about that. And we did go out and deliver by hand many of the things. Matter of fact, I'm gonna say Mrs. Bradley back there, one of my representatives, but she chewed me on why I didn't get a hold of her sooner and let her know all these things are going on. I met Mr. Benson there by going through all this, so a lot of good things I've gotten. I don't know if I want to say closer, but to the city, I met you and we've gotten along good, I think, through it all, so some good things have come out of there, but I think it's time that we back up. If we want to take another look at it, if we want to wait for the city to take, go forward on it or something. But I think there's been so many headaches in it, and I think the city may be looking back, maybe they would realize too, if the people would have been notified right away, maybe things would have been different. I'm not gonna put you on the spot. But it seemed like the county had to go ahead and push that through, that we're the ones that notified all the people out in the country of it. We sent out the letters, we got it going. The staff here got a meeting together out at the airport, and the city come in and put on a thing, but we never sat down and like the rural people, the landowners, if they wanted to stand up and talk, they could, but they could never get up and give a presentation like the other ones. And I said that if this ever comes up again, while I'm chairman, they will have a chance to do that. So hopefully it'll never will come up again, but I'm sure that it will. And so that's one of the reasons I think we should take a step back. We heard a lot of negative going back and forth through this also, good, bad, and different. I don't know, but like Mary Beth said, shenanigans, I don't know if it was or not, but I just think that we got to back up, start over, and just see what's all happened. And maybe some of this is going to come good out of this. Vincent there said that, yes, we do have to work with the city of Oshkosh, but does it have to be with them landowners? You know, maybe we got to do something else as a department and work with them and get through this. Are we doing our jobs? You know, that's another thing. We shouldn't just be pushing buttons going each another's way. Maybe ourselves as a committee and our staff and all this and that, maybe we're not doing our job. So maybe we should back up and take a look at ourselves also.
Two quick things. One is for you, Jerry.
Mhm.
If we would approve item C. And if at some point this would be brought to your department, that we would be in favor of them reapplying for the permit. The signatures on the permit of the landowners is important to me. So how does that go down from your department as was
Well-
presented by Mrs. Bradley?
Yeah, if an application was made by the city is the applicant.
Okay,
And if I'm not mistaken, the city actually has property that it owns in that area, so they are actually technically one of the property owners.
okay.
And that application can be made by a multitude of property owners or one property owner. In this case, the city of Oshkosh.
Okay.
And so the city would be the applicant. We would. There is no, at that point, if there is an application made outside of it being a county application, which it currently is, or in the past has been. At that point, that application by law would have to go direct, would have to be pushed to public hearing. And then eventually deliberative by this committee and then action by the county board. It would go through the normal amendment process that normally happens with any zoning change.
So if we would vote for withdrawing this,
Mhm.
and the consensus was because we wanted this to start over again. What would be this committee's next step? Because we can't take any action other than
Sure.
what's here today.
If there's an application made by the city of Oshkosh to move forward with this amendment. Staff would process that application. You know, there would be a notice in the class 2 public hearing notice. The normal process of a zoning amendment, so it would be placed on a future public hearing
Mhm.
agenda. You know, that public hearing would occur and then followed by deliberative by this committee as far as your decision as to whether you approve or deny that particular application. And then whether it's approved or denied, it goes to the county board as an approval or denial. by this committee.
As is normal.
Yes,
So our vote on this, I see, puts this back in the hands of the city to make their decision. Would you agree with me on that?
I would, the
There's
city or
nothing that
any
the
other
coun-
landowner who may
Right.
want to file an
Right, right.
application.
And the people who came to speak today, they could file, right?
I have another question, and I think it might follow up somewhat with Mary Beth's on the signing of the land and this and that. When Mrs. Bradley spoke about her history on the farm there and her husbands and all this and that. So in other words, if the city does it, they don't have to have them sign that whatsoever, being a landowner.
Right,
Am I
right.
correct?
Right.
Assuming the city is a landowner, and you think they are.
yeah, the city owns.
Okay.
But there's going to be
By
public
rights
hearing.
before,
Yeah.
by rights
Right.
before, should have all the landowners have to sign? From say if it was as of today, should have they all at that time?
That application was actually a county sponsored application, so the county actually has an interest because it's a county ordinance, so the county was the applicant.
Okay,
In that particular case.
so in other words, the landowners wouldn't have to sign. it.
Yeah,
Okay.
and
I don't want to get
Yeah.
anybody upset, I just wanna
right.
understand
And
for
that
myself.
that application is a standard, a standard application that goes with all zoning amendments. So the county is the applicant. And therefore it has the right to amend its own ordinance.
Okay. Thank you.
So the public hearing is the savior of any information that would get to the people
Mhm.
through the public hearing.
Yeah.
And the notification to
Mhm.
those people.
Now, I would certainly would hope that there would be some meetings, informational meetings that would lead up to a future application, but again, if the city wanted to proceed, next week with a new application, I mean, we would have to take that application and move it through the process.
And you would be in charge of putting on the meetings if.
Yeah, I mean,
wouldn't be
yeah,
the
our,
city.
yeah, we would have to move it through as a normal application. Yes, it's part of due process of law.
And if we withdraw, this application, does your office send a documentation letter to the applicant that it has been withdrawn, like a not just what went on here today, but if we withdraw, how does the city get notified?
Well,
I know he's sitting here. I know
If he
he's
wasn't here.
but that's,
Well, I
if-
mean, we could.
There's
I mean,
also that right there, the camera.
Yeah,
You know,
I mean,
They keep track of our stuff.
we don't have to.
word
send it.
will be,
They'll
yeah,
be in contact.
yes,
and I can, if you want, formally notify the
Sure.
city in a letter
Okay,
saying planning and zoning met today and this was withdrawn,
that would make me feel
Well,
better if that's.
yeah,
if that's what
Yeah.
happens.
that,
Okay.
that's a
Okay,
good
and then
idea.
you're all right with that.
Oh, yeah,
Okay.
yeah.
And if I can throw one question in here, I just can. And I just want to make sure this one is really clear. Can the city decide, because if we rescind this, to directly petition the DNR for the mapping to occur? I believe that is,
I think there's, yes, I think there's some process there. I'm a little, again, unclear exactly how that happens.
And I am as well, but they have every
but
right
it's,
to file.
it sounded
an
to me,
application.
it sounded to me at the last meeting,
Yeah.
that was the case.
Yeah,
What,
Yeah, go ahead.
I was gonna say what bells and whistles they have to go through on their end
Mhm.
to come here, I don't know, but I'm sure their corporate counsel will be able, knows what has to happen.
I know, I was assured that they didn't want to have to take that route.
Oh.
After our last meeting concluded, we left everything in limbo. I had talked with Mr. Roloff and he said that that's not, he doesn't want to have that kind of animosity between the city and county. He wants to work with the county, so hopefully that would come back through. But if the option's there, I'm putting that out there.
Well, the situation has changed. If in fact this committee votes to
Mhm.
basically withdraw the application, then the scenarios change. So maybe that might change people's ideas. I don't know.
And that's just something that weighs heavily on me, is giving up any say on the matter. Potentially giving up any say on the matter.
Does anyone here, and I don't know, I don't want to put you on
Mhm.
the basis of this, but what happens if the city goes to the DNR? Is there a permit that has to be filed, or is it an email? Is there a documentation that has to go down for them to go directly, if they chose that as an option, to the DNR?
So the specific,
Unclear
the
exactly.
specific verbiage I heard was petition.
yeah,
DNR.
there would have to be, yeah,
Okay,
exactly. I'm sorry, but I'm not
they
familiar
would
with
have
that
to
process,
petition the
so.
DNR, and the DNR.
The
would tell
onus is on
what-
them, that I know.
The DNR would tell them what that petition.
Yeah,
is.
yeah, and then the DNI would evaluate it and.
I know that at
I'm not
One
trying to
of-
throw a wrench in the works. I'm just trying to
No,
make sure
that's
we
fine.
have that out there.
one of the last meetings. Maybe it wasn't, maybe it was the one before that. I know that there was the corporate counsel for the city of Oshkosh, but they also have retained an outside firm.
Mhm.
And I don't know if that firm is still on retainer. I would assume they are, but I'm sure they know what needs to be done.
Mhm.
I'd like to know from Mr. Bodie if they're still on retainer.
I don't know.
make as far as today?
Yeah.
It's whatever we want to do.
Okay.
Right.
That's just my opinion.
Yeah,
That should decide our opinion, whether they got another attorney on or not.
Strike that.
That's just my opinion. You go ahead and ask them.
No, that's fine.
and I just want to answer one question about how this came back. Again, was at our last public hearing meeting, it was asked by Supervisor Estera if how we would go about bringing it back, and I'm the one who sets the agenda, and I decided that we were gonna give it another kick because it was asked by one of our members. That we have another kick at the can. Well, the reason this is on the agenda is because I asked them to. The whole reason this has been going on in this last elected term is because it was sitting in limbo. And it's not fair to anybody to have it sitting out there with no resolution. My goal throughout this process has not been to pass it, not been to rescind it. It's been to get it in front of the county board to let all of the representatives of people who live in that area make a decision, not just this body. So I have it, that's been my agenda throughout all of this. It's not to get it passed, to let the representatives of the people in those districts all have their say and have you guys come in and have your say. Actually, in a more public setting. Because not many people watch this. Not many people pay attention to this. A lot more people pay attention to what goes on when there's 36 of us together.
I don't wanna throw a wrench in here, but as far as representatives for that area, they're sitting at this table. So when you say representatives from that area, if you should be saying representatives from the whole county,
Mhm.
because it's whole county, not just that area,
Well, Sawyer Creek affects a lot of the city too.
right?
So I mean, it's all the downstream stuff. I mean, my district isn't anywhere near Sawyer Creek.
But as far as the outlying areas,
Yeah,
so.
Just another clarification. Is the DNR running this ship or is FEMA?
I think FEMA is, quite frankly.
And are they doing it through the DNR?
well,
They're
That
working
she's-
hand in hand with
The DNR
Well,
representatives?
and that assumption would be validated by the insurance thing. The flood insurance,
And
the
we're
FEMA
back.
flood the FEMA flood insurance.
And the official correspondence
Mhm.
that's being sent.
Because it was
That's what was my
Yeah.
concern.
FEMA is the driver,
Right, right.
but FEMA
So that,
doesn't talk to us other than email. So.
well, no, there was letterhead.
Right, but recently it's been the DNR.
Yes, that August 21st correspondence was. This person is from the DNR?
Yeah.
Yeah.
Michelle.
Yeah, okay.
All right,
More discussion, or do
Yeah.
we want to take a vote?
Well, I would like to take opportunity since we have various people here, and I appreciate the time, but I guess the whole FEMA and DNR and running it, you know, we have a say at the county level. I mean, big time, more than I think sometimes we realize. And I guess I have as far as the comprehensive plan with Bill Benson's feedback, I took lots of notes on that, and I just would like to get clarification on. So I think you're in charge of comprehensive, you oversee that, right, Mr. O'Rourke?
Mhm.
Okay. So how does the comprehensive plan address flood mapping and storage?
It doesn't, because that's not the intent of the comprehensive plan.
So this is not something that
No, it has
is in your
nothing-
wheelhouse.
It has absolutely nothing to do with the comprehensive future land use plan.
Okay, thank you. So then, what I heard him say, and I wrote notes because I tend to agree with what he's saying, of course, but the responsibility of the committee is to steer what we're doing for the county. We should have a transparent, collaborative efforts from all different experts. I know Mr. Miller is on a drainage board, right? And you've got the Army Corps of Engineers and all of these different things. All these, and the city, Mr. Godey is on. You have experts in your department on water, is that right? There's all kinds of experts. So what I hear is being proactive about future flood mapping. Is needed. Would that be something that you would agree with, that we need to be proactive from this experience?
Well, we.
I would, can I
Sure.
I would just say, and again, I'm quoting from this FEMA letter, and again, these people are. The hotshots as far as I'm concerned in the area, and I mean, we all have a lot of experience, but. When I was talking to you at the last meeting, the concern I had is that. This board is on notification. That to quote, continue participation in the National Flood Insurance Program, your community. Okay, must use the modified flood hazard information to carry out the floodplain regulations for the NFIP, okay? And I'm trying to see what NFIP is, National Flood Insurance Program. And then again, as we've talked about, after that, we were getting, or the county was getting correspondence saying, again, FEMA can immediately suspend Winnebago County from the National Flood Insurance Program. Just so But you're all aware of that. And
Yeah.
we've talked about that.
Yeah.
Extensively. And so that's where we're at.
Yeah, and those are very big statements. I feel a little, we've had that brought up. And it's kind of like this threat, and I understand it's coming from a FEMA or DNR, but
I don't think it's vague, but that's fine. Everybody's
No.
entitled to their opinion.
I didn't say vague.
I thought you did, but maybe I misheard you. Okay,
No,
Okay. okay.
I have some questions for Mr. Godey. Is that how you say it? Sorry, okay. Do you think residents should have thoroughly been contacted? Were you concerned at all about those residents that were not contacted? Did you think about that? Was that in your radar at all when the county was dealing with this?
Using city procedures and protocols, because that's what I'm familiar with. The application in doing that automatically generates notification. That's what the city was relying on. This was a county application, a county action. The city assumed the county was doing the notifications as a result of the actions.
Okay, when did you learn that that didn't happen? And that not necessarily putting blame on anybody, but when did you know?
I couldn't give you a date going back over the history when we do that.
Okay. Do you think we should be proactive on flood mapping from this experience? Because there's a lot of mental duress that's going on with the residents. There's it's a lot of, for people who aren't being compensated. They're not doing this for a living, the landowner and owners and everything. Do you think from that experience, that sacrifice, etc., that we should have collaboration about flood mapping in the future? I don't mean to be so bossy about the way I'm saying it. I'm just trying to communicate.
I have a difficult time coming with an answer because there are so many different avenues I can do that can happen.
Yeah, but it seems like nobody's really working together, in my opinion. Do you see that at all?
My understanding is that FEMA could come tomorrow and decide they're gonna map it, and there would be no notification, collaboration, or anything. FEMA would say, we're mapping it, and here it is, and it's done.
Yeah, that's true. That's a possibility, but we could also be proactive and work with FEMA as well as what people are doing together in the community for their own land in their own area.
And I hear that, my understanding of the mapping process is it's what the model shows. It doesn't matter what people necessarily feel or want. It's the result of what area is gonna flood. That's what gets mapped. It doesn't matter that you don't necessarily agree with it or that you want to necessarily carve out an area. The FEMA and the flood mapping is what areas based on the model inputs and the terrain show floods. That's what becomes mapped.
And one thing I have a question for with Mary Ann is, isn't there a conflict of interest when the city owns property along Sawyer Creek and then they take, they own property along Sawyer Creek, but yet then they're pushing this, not they're pushing, but you know what I mean? That just seems a little bit of a conflict of interest that the city itself owns property along Sawyer Creek.
So that's why they would have standing, assuming they do own property,
They
to
do.
file the application. So I mean.
The city's allowed to own land.
Well, sure they are, but the city is, okay, well,
No.
I just have concerns about some of that and there's also concern about Freedom of Information Act. Bill Benson has told me that he still has not received information when he's requested it. Is that true?
That's because the document doesn't exist.
Okay.
And it's sitting with with FEMA to see if they have this document that is being requested, the signed, so-called signed version of that particular document. And at this point, there is no word from FEMA whether that document exists.
What document is that?
I don't even remember what it's called.
Okay, can I ask Mr. Benson what that is? I guess the whole overall thing is, go ahead, Mr. Bougie.
So that. You know. We've acted on the. Open records request by Mr. Benson.
Okay.
We have requested from both the city of Oshkosh. And the engineering consultant for the city of Oshkosh, if they have a copy of that document or the original, whatever signed version. We have been notified by those parties, they don't have one. We contacted DNR, they don't have one. DNR contacted FEMA, and that's where it sits, and we have not heard anything from FEMA.
And can I just point out, as you probably know,
Yeah.
with the public records, the county is only obligated to provide what they have. So planning and zoning provided what they have, and listening to this, it looks like they went above and beyond.
Right.
In terms of contacting the
Trying to
DNR,
track
contacting.
it down
didn't have
if
to
it
do that.
exists.
And
Violated
that's
law.
fair.
So they
I,
went above it just to look.
yeah, and I appreciate that. And I believe that. Can I ask Mr. Benson what that document is? Because that does bear on our decision, I feel.
Sure.
Okay. What was that, Bill?
That, the document that I requested is part of the FEMA application. It's called the Overview and Concurrence Form. FEMA, in approving a letter of map revision, requires that every community sign. Every community is notified, and that the CEO of each community sign the application. Because this letter of map revision was requested by the city. FEMA requires that the county would also assign that application because the county is an affected community. If the document doesn't exist, then the county, that would imply that the county never signed the application. Which would. I said before when I spoke, the county never signed up for this. There's yet been no documents provided that the county was ever on board with this from the beginning. And if the county didn't. If the city doesn't have it and the county doesn't have it and the DNR doesn't have it and FEMA hasn't been able to find it within over a month. And as Mr. Bougie said, if the document doesn't exist, then how did this study get approval? After FEMA asked specifically for the city, for the county signed application called the Overview and Concurrence Form.
Okay,
And then the question I'd have is,
Substantiates if the county never signed up for it.
I would
To
just,
comment on FEMA's, FEMA does not recognize. Flood storage,
Yeah, I just don't.
it's not in the floodplain. FEMA's not asking you to approve flood storage.
Mhm.
It's a state, it's not regulatory for FEMA. If you go look at the FEMA map right now, there's no flood storage on.
Not trying to be,
It's a
No,
state
but-
not trying
directive.
to be disrespectful.
Thank you.
You just needed to answer the question and.
Thank you.
I call the
and
question.
to just, to clarify one,
I call the question.
I had a very important question to ask her.
question's called.
Yep.
Do you have a second?
All those in favor, signify by saying aye.
I,
Any opposed? Nay.
I'll be a name on that one.
You're, like you said, you stated both, so you're nay.
Yes, I'm name.
3-2.
Who else was in here?
Me and
Yeah. Item number 4, discussion on shoreline zoning.
That was just sorry.
No, that was just
Oh,
calling the
oh, that
question.
was
Now you're
calling
gonna,
the call.
move-
Sorry.
that's okay, that's okay.
All right, yeah, okay.
So
Moved
here's
and
the motion.
seconded, so yeah, I did what I do at your meetings.
I know that's what you do.
With, so we're voting on withdrawing the Sawyer Creek floodplain amendment application. Any more, that question's been called. All those in favor signify by saying aye.
Aye.
Any opposed? Nay.
And the committee is directing me to notify the city's corporation council of this vote.
We're authorizing you to do that?
Yeah, are you?
No.
I just
Yes,
want to
please.
verify.
Do we
Yeah.
have to do that?
As a courtesy, I thought that's what.
I don't know if. Why do we need to do that?
Why not?
Why not? It's a
Okay.
courtesy.
Okay, it's
mean,
good
it's
to
a
be
courtesy.
courteous.
Here, it's on there, so why not on the
Courteous.
it's
And it's coming from corporate, so.
And we have her here to say that I'm
Okay,
willing to
yeah,
do that.
that's fine.
Because that's what we were. That's just, that's. a-
I agree. I haven't had my coffee.
We're just gonna be courteous about it.
Yeah. We will be courteous.
Okay. Item number 4, discussion on shoreline zoning authority.
Sorry, Diane.
Attachments.
Thanks, Marianne.
Well, I think I may have to be here for a little bit, not much, but I have my computer taking it, I think by 9:30, so. Yeah. You need to be done. You guys want me to?
Yeah, if we could. Mr. Chairman, you had suggested this be placed on the agenda.
Yes, and this is Supervisor Miller's, darling, if you would like to explain that, you probably explain things much better and clearer than I would, because this is your document.
Okay. I'm looking at this as trying to get
Oh,
the
thank you.
county and the towns to work more closely together on shoreline zoning.
Mhm.
Okay?
Yeah.
I think it's a waste of time and money for the towns to hold a public hearing on this and have the county do the same thing. I think that's a redundancy. I think they should all be handled. The public hearings should be handled at the town level. You know, if there are, you know, I'm not trying to get the county to abdicate their authority or anything, because there are certain things that the county has to be responsible for, like setbacks and, you know.
Well, and also shoreline zoning per the Hedgewood versus Town of Eagle zoning board of appeals case that was handed down. But, and I will tell you, and I don't mean to interrupt, it does say the Court of Appeals said, based on our review, we conclude that except for a limited circumstance, which did not exist in this case, it is clear that our legislature has given shoreline zoning authority to counties. And it goes on to talk about, and actually, we even have the Brian Ohm, who's like the guru for planning and zoning, references the fact that, so 59, 69.2.2a says that ordinances and amendments related to shorelands and enacted under 59.692, quote, shall not require approval or be subject to disapproval by any town or board. But it does say that a county ordinance enacted under this statute, shall not be effective in any town until it has been approved by the town board. That was in the past. But there is a specific reference that says that, and I'm trying to find it, basically the Act 41, allowed a county to continue to enforce portions of its ordinance that impose greater restrictions than the county ordinance imposes. So essentially, the county is the one who oversees shoreland zoning, but for a section per the decisions that said if there's a section in the town which is more restrictive than county zoning, that could apply. So anyway, but I didn't mean to.
Only if
It wasn't addressed.
only if the town had a zoning ordinance back
Right.
when in 1968, I believe, when the county adopted shoreland zoning.
Mhm.
Only if the town had an ordinance in place at the time.
Right. Right. But anyway, I'm sorry, I'm sorry, I wanted to make sure because I might.
Just
have to
feeding off
think-
of that real quick, so they can't go in and have a create a new ordinance that would be more restrictive, is what I'm getting.
That's
Right.
correct. They can only,
It's only grandfathered in.
they can only come in with an ordinance that doesn't address the matters that are addressed by the county's
Mhm.
Okay.
ordinance.
Mhm.
Sorry. I just wanted to-
Anyway,
That's fine, that's fine.
Yeah.
You know, that
Yeah.
kind of leads into my next comment. You get two attorneys and they look at it differently.
Absolutely. Yeah.
Okay. I have here a document, it's a memo that was addressed to Dave Murphy. And I know you in planning and zoning have seen
You
this
have enough
before.
for,
I don't have enough for everybody, but
That's-
I know you've seen it before.
Oh, thank you.
And this kind of disagrees with that
Mhm.
statement. And this is from the Wisconsin Legislative Council.
And guess what? This was from the legislative council also. So they may be disagreeing with each other.
And
Although in fairness, this was, let me see, what is the date of this? I'm trying to say. This was 2015, yours is 2020.
yes,
Okay.
and this addresses legislation. It was Act 145, which was adopted in 2019.
Mhm.
And it goes into the background and it goes into the background and talks about the intent of the legislature when they enacted this legislation and some of the court cases that have come up and the change to the state code, which was Act 145, to give joint authority to the towns. So, I think there should be that joint authority.
And I just.
And I think from where I'm trying to come from is that let's let the towns have the initial look at it. Okay, let them do the public hearing. If that still has to come to this committee, that's fine, we can be an authority of overviewing it. It doesn't prevent the county department from looking at it and making sure that everything is where it needs to be. All I'm trying to do is to eliminate the expense of a second public hearing. And what we just went through this morning with this in Clayton. Whatever
Oh,
that
I thought
that
Clayton.
subdivision, here's another case. Where both a public hearing at the town level and at the county level. Why a duplication? Why are we doing that? That's really where I'm coming from. I'm trying to save some money and save the headache of having all of these developers, first deal with the town and then the county.
Looking again, just quickly skimming this 2020 Legislative Council, it does recognize, with some exceptions for pre-existing ordinances, towns are generally not authorized to enact or enforce shoreland zoning ordinances. So again, the Legislative Council referenced that. And again, I'm just quickly looking at some of this. And then again, it talked about the Hedgewood decision, which I just quoted out of, right? That specified that towns may enact zoning ordinances that apply in shorelands, except that a town may not enact new restrictions or requirements with respect to matters regulated by county shoreland zoning
I
ordinances.
think what Howie's getting at though is after the summary of current law at the bottom of the page, because it looks like in 2019, they had Act 145,
Mhm.
which.
Yeah.
To apply
Am I
their
right?
general
Yeah.
shoreland. Well, Wisconsin authorized towns to apply their general zoning ordinance within shoreline, except with respect to provisions of a general zoning ordinance that regulate a matter regulated under a county shoreland zoning ordinance. So that's like clear as mud, quite frankly, which again, I guess lawyers can do.
Yeah.
But even if they had jurisdiction and authority, you know, I see with some exceptions for pre-existing ordinances, town are generally not authorized.
Mhm.
They're still able to govern the request, and then the staff members, people that know the statutes, the laws, et cetera, they're able to just oversee it, right?
This is their interpretation. I look at what the law is, and they're referring to this Hedgewood decision. And again, as far as Hedgewood
Mhm.
is concerned, I believe that it's the shoreline zoning is basically going to what the counties say. I
Would be very careful about compromising the county's mandated responsibilities, state mandated responsibilities in the shoreline zoning areas. I'll come right out and say it, Howie, I don't know why the town is having a public hearing. It may have a public hearing that is dealing with matters that the county zoning or shoreline zoning ordinance doesn't deal with. It may be holding a public hearing on that basis. However, the shoreland areas, the public hearing that the Planning and Zoning Committee conducts is under their responsibility, and it is due process of law. And an applicant that makes a request, for instance, for a zone change in the shoreland area is entitled to due process as spelled out in state statute. And that application comes to our office, we process it, this committee conducts a public hearing, it deliberates on it, and it goes to county board. That is the process that is enumerated in state law. And to conduct a public hearing, let the town conduct the public hearing, there's no authority for that.
Well, here's the problem that arises, and here's a shoreline zoning map of what we
Okay.
talked about today, okay? Now, recognize at the time that this was initially done,
Sure.
this was not a navigable waterway. So 99% of this 100-acre property
Sure.
was not in shoreland zoning. Only this tiny little corner up here.
Yeah.
Now there's a strip that goes through the middle. I don't know exactly what that
Yeah.
is because it's not delineated on any of our maps yet.
Mhm.
But regardless, it's a strip through the middle. So the town has to have a
Yeah.
public hearing on everything that's not in shoreland
Yeah,
zoning.
that's under your zoning, yes.
Okay, so why not do it all at once? Why not let the towns deal with this? And we get the results of their public hearing and save some money.
The problem is on the statute, if we go to 59,692, it specifically says ordinances and amendments shall not require approval or be subject to disapproval by any town or town board. So in other words, it's essentially going against what this statute is saying. You are trying to take the authority that the county has per statute away, and I can understand your intentions. You're trying to
get it
save,
too.
I absolutely understand that. But I am concerned about that.
Okay, I'm not trying to take the county's authority away. All I want to do is, all right, let's have the public hearing in the town hall once, and rather than have two public hearings.
Well, they don't have to have, I mean, we have a public hearing. The town is not required to have a public hearing.
Unless it wants to change its own ordinance.
They're required because you know, they're gonna have the public hearing on this entire parcel.
Mhm,
Okay,
mhm.
all we're really looking at is what's in shoreland. So we're looking at some kind of a strip through the middle of this. They're looking at the whole thing.
Mhm.
It
But-
makes more sense to me.
And the committee can't defer its mandated responsibility to address a zone change in the shoreland area. Am I correct, Mary
Yes,
Ann?
you are.
I mean, I don't mean to answer.
No,
that.
no, that's fine. I mean, quite frankly, you've been dealing with this for decades, so you are semi-familiar with it, but I'm looking at the statutes. That's what I'm.
Yeah, but
That making me sound old. Yeah. I
No,
know.
I'm probably,
Yeah.
I'm older than he is.
Yeah, what's up with that?
But that statute doesn't require a second public hearing, does it?
No, but it does require that the county maintain its responsibilities. And to do that, they have to have a public hearing.
What, do they have
So
to have a public hearing to make?
Yeah.
Actually, if I can kind of clear some mud here.
Yeah,
Legally, they can't have a hearing on that shoreland.
they
The,
who,
o-
The town.
the town.
yeah,
The only people that can talk about the shoreland is us.
that's right.
So as far as we're concerned, as far as that statute's concerned, there's only one hearing on the shoreland, which is at the county level. That's how I'm interpreting it.
Well,
And that's the way it's supposed to be legally.
Except where there's a prior, or there was a prior, amendment.
Ordinance.
Ordinance back
That,
in-
that has
And
not
that was
been
pre-60, 1960 or
68,
something?
and it can't be amended. If it's amended once, that disqualifies it.
Yeah.
Okay.
where exactly are you interpreting that? Because I'd like to see.
That's
That's-
what Mary Ann
Can
was
you read
just
it?
What
explaining
all
to
of
us.
this
Okay.
is, I mean,
Read it again now.
you can get down into the weeds on this stuff.
Well,
but
sure
I'm
we
just-
can, but I
Yeah,
still
no, I
want to hear
understand.
it.
Well, the reason, here's where I'm getting it from, because when you read that, it says the authority is the county.
Mhm.
Which means that the
Yes.
township has no authority to ever even have that public hearing about shoreland zoning. Therefore, we are the only one who is having the hearing on the shoreland zoning.
But it does, okay, could you read it again? Please,
Yes,
I'm sorry.
sure.
Mary. And when do you need
Okay.
to go? I'm sorry.
I
Yes.
have to, I
Mhm.
should have left, but I'll just quickly finish this and I can just tell the judge that it's planning and zoning that made me wait. How's that? No, I won't say that. I will.
them our phone
No,
number.
that's
Thank
right.
you, Mary Ann.
That's fine.
I'll straighten them out, just give them my number.
Okay. So if we go to 59,692, which is entitled zoning of shorelands on navigable waters.
Okay.
When we go down, it says, except as otherwise specified, all right, all provisions of 5969 apply to ordinances and their amendments acted under this section. But the ordinances and amendments shall not require or approval or be subject to disapproval by any town or town board. And then it goes on to say, if an existing town ordinance relating to shorelands is more restrictive than an ordinance later enacted under the section affecting the same shorelands, it continues as a town ordinance in all respects in all respects to the extent of the greater restrictions, but not otherwise. So that is where, I mean, I am looking at that authority and
Yeah, so, okay, so, as far as authority goes,
Mhm.
if you had a town hearing. And they are talking about, they address shoreland, but they are not an authority of it, but there is. They can have a recommendation to the staff. And I don't know why we'd have to have a separate hearing. Because I don't see that
Yeah,
it's.
it's an advisory.
Sure, and why do we have to have then a separate hearing because
We
it's.
don't have it on a separate, it's clear in the state statutes that the county enforces shoreline.
Mhm.
And the parameters of that require a public hearing by the planning and zone committee of the county.
So it
the-
requires a hearing.
So the town that's holding the
Yes.
hearing is
Because-
actually unnecessary. Not the counties, we are mandated by state statutes for that procedure.
The town of Clayton and Winchester adopted their ordinance in 2012. Ours was adopted in, or comprehensive rewrite was done in 1978.
60.
Or, like I said, the comprehensive version was done.
Yeah.
But yeah, we.
Yeah, I'm gonna have to make a phone call. 'cause my
Just as a
son has-
side note, and Jerry, since you're
I think we're
so,
very close to.
this comes, we saw in our township Act 145. And if you remember, our town chairman challenged you on that. We got a letter from the state
Right,
and he challenged you and said, huh, we can do our own.
Yeah.
And you said, not the way that it's being interpreted.
yeah, it's only matters, I mean, the town could have an ordinance, but it can't deal with matters that
Right.
the county's
So
shoreline.
we never
does.
did anything and we have a lot of
Yeah.
shoreland in our town.
You know, if you wanted to create an ordinance and try to regulate something that the county shoreline ordinance doesn't,
Would-
the town could do.
Could
that.
do it, but we never did because.
Yeah.
Even with this act. We still
Yeah,
abide by shoreland zoning
right,
being,
exactly.
being designated,
Yeah.
handled by the county.
You know, I appreciate you bringing this up.
Oh, yeah.
This is actually a great discussion. I think we're all learning.
But it's, you know, the county's authority here is
Paramount.
not only authority, but it's the process that a property owner is entitled to under law. It, you know, it specifically includes the planning and zoning committee because they are the committee of jurisdiction over this. And it's the responsibility of this committee to follow through with that to ensure due process. And short of that, this committee can't defer its responsibility to another governmental entity to address that application. Because again, it is a county ordinance. So no,
Any other discussion on the item? Not, I'll accept a motion.
I'm gonna have one more bit of the second, back to this one. So when this initially came before the township, this wasn't in there, so.
No,
Just this little piece.
it's this little corner.
Yep.
Right here. That's all that was in shoreline.
So I can see why you would have had a hearing,
yeah.
why the town.
Even after this, it's just a strip,
It's a strip, I get that.
I know, but
Yeah.
it's,
you know, and
I'm-
to me, that's. Two public hearings is redundant. It's expensive for the county and it's expensive for the landowner.
yeah, and I don't deny what
Yeah.
you're saying, Howie, but unless state law is changed here to, you know, sort of, you know, allow for such a thing, and that little strip is the responsibility of the county, unfortunately. Okay.
I wish we lived in a world where that could work.
Yeah,
It would,
I
I
really do. I mean, I wish, you know, I wish state law could be changed to address these, you know, these nuances that come up like this. And it, on the surface, it does look, you know, like a bunch of nonsense, but in reality, this committee is responsible for addressing that strip and the zoning that occurs there. And so
Yeah,
I
legally that strip wasn't technically dealt with
You know,
because it
and
was improperly
and
delineated.
and apparently, again, the property owner decided not to ask for navigability, excuse me, determination. And which then, you know, maybe the process could have been simplified for the property owner and, you know, the town and even the county. But he decided to move forward and without getting that determination and you know, so, but I understand the frustration. I do, because it does seem like a lot of extra work for,
And it's.
or I don't
It
disagree.
seems unnecessary
Yeah.
and I, you know, look
Right.
this over and I
So,
think.
And I
Are
had a
we
question
supposed
for
to-
you that I was gonna ask too. I
Thank
know,
you.
I know
Thanks,
you have
Mary
to go. I know you have to go.
So are we supposed to be voting on this today?
No,
No,
Okay.
there's
There's discussion.
just discussion.
That's why it says discussion.
Okay, all right.
So that's why I said I will accept a motion.
I'll make a motion to adjourn.
Second, discussion's over, I guess.
Well, I did have a question.
On the discussion,
Well, I'd like to hear one more. I mean, he obviously,
You know, look this over.
We just got this today, so.
You just got this today.
So I
Look it
I wanna
over,
read
see
it.
how you read it.
I wanna read it about 5 times.
Absolutely. Yeah, absolutely.
okay,
Sure. Because you
so the motion's been made and
oh
seconded.
yeah, you need
I'll
a,
read it.
he doesn't have a copy of it.
That's all right.
Okay.
Motion's been made and seconded. All those in favor of adjourning?
I,
Thank
Okay,
you,
okay,
everybody.
okay, I have a question. Maybe you guys can answer this.
Did you not give them?
Is Winnebago County covered under FEMA flood insurance?